Um, so we're going to get started, and I'm so glad Curt Hartman could be here tonight to talk with us for 15, 20 minutes before Dean gets started. Curt has been a real friend to EmpowerU and has spoken about Open Records and Open Meetings Act many, many times. We haven't had him in a few years. We need to get him back. But I had a chance to talk to the Turning Point group tonight down front. We talked about how to get information from your government and how to do that and what's the right way to do it. And there's something called the Open Records and Open Meetings Act, which allows you to get almost anything you want if you do it right. But a lot of Republicans and other legislators are making that law a lot less transparent and a lot harder to get information from government. And when it's so hard to know what government's doing, it's disappointing to see that law kind of getting watered down. So I asked Curt to come in and talk to us about that. Curt is a former judge. He's an attorney at the Finney Law Firm, where he concentrates on commercial and constitutional litigation, as well as public interest litigation. He holds a JD from Vanderbilt Law School, an MA from Georgetown, and a BS from the United States Naval Academy. Would you guys welcome Curt Hartman?
Great. Thank you, Dan. And I do appreciate that everyone did not show up tonight just to hear me speak. So I think it's going to be a great show here in a few minutes. But appreciate the opportunity to kind of give an update. As Dan said, I've given presentations for EmpowerU and elsewhere on the Open Meetings Act, Public Records Act, which basically go to the core of openness and transparency of our government. And as Dan has indicated, the General Assembly, through the Public Records Act, has been constantly constraining those records that are available to us as citizens. And it's kind of disappointing because you look at what the Ohio Supreme Court has said about 50 years ago. They said that the principle underlying public records and the Public Records Act is that the public records are the people's records, and that the public officials who hold these records are simply serving as custodians or trustees on behalf of the people, and that therefore the people have a right to the access of their records, at any reasonable time. That's a high, lofty philosophy, but then when the rubber meets the road, it also often becomes challenging. And honestly, the current and past General Assemblies have not been a friend in that regard, nor has the Ohio Supreme Court in terms of interpreting the law. And so there have been a few changes really in the past year, a couple bills, the state budget bill that imposed additional amendments to the Public Records Act. Now, what is a public record is really quite simple. It is any record, which means any document, regardless of its form, be it electronic or otherwise. That is kept by a public office. So it's got to be kept, and that's one issue. And I'm not going to give you the whole 1 hour show, but it's got to be kept by a public office that serves to document the functions, operations, policies, decisions, operations of that public office. So generally very broad. But then you look at the act, and over the years, Public Records Act went in the mid-1970s, but since that time, the General Assembly has said, yes, that is a definition of public records, but there are certain exceptions. We're going to start saying these type of records, even though they fall within that definition, are not public records. And to date, they have put in over 52 exemptions. It goes A, B, C, D, we're past double Z. So we've got about 52 exemptions from those public records. And some of the most recent ones, and not only do they exempt records, but they also put additional hurdles. And one of the most recent hurdles that they did, it was back in April of this year, the General Assembly, one of the things that is a public record are police videos, body cam videos, police cruiser videos. We see them on the news, people who are the victims or want to check on the police, hold them accountable. Say, hey, I'd like to see a body cam from this police engagement. And that is a public record. And while the General Assembly has not exempted those from the definition of what is a public record, they have empowered, if you will, law enforcement agencies to charge you for the preparation of that video. And General Assembly in April of this year said a state or local law enforcement agency may include in its public records policy, the requirement that a requester for a video pay the actual cost for the preparation of that video, including the redaction of that video. And they said you can charge up to $75 an hour, no greater and no more than $750 total. Yeah, yeah, if you think about it, you're trying to find out what happened in this incident, you got to start paying the government. And the government doesn't even have to start preparing the record until you pay their estimated cost for that. And then later in the year, they extended that to county prosecutors. If the prosecutor's office has to prepare a video for you, they too can charge you up to $750 for the preparation of that video. Previously, they would prepare the videos. You might pay $1 for the disk drive or the USB drive that the video came from. Even sometimes they just download it on a file sharing. So that's one of the, yes, they haven't exempted video records, but they are making it much more difficult. Now, again, it's got to be actual cost. I will tell you the one example I can tell you, recently I was aware, we all know about the brawl or the melee that occurred down in the city of Cincinnati. There are police videos from that. The police, when they finally did show up, had body cameras. And the preparation of that was about $20 is what they charged for that. So that was kind of a reasonable cost. But one way I got around it was I wasn't the first one to ask for it. The news media had asked for it. So all I asked for was, I want to see the responses you provided to people who have asked for this video. They didn't have to prepare anything for me. It was already prepared. They tried to push back. I pushed back and they just gave it to me. They weren't going to have that fight over that. So there's ways around it if the video's already been prepared. But again, putting in this requirement to make people pay, again, it undermines that philosophy if you think that these are people's records, not the government's records. Let me find another thing that they kind of did to restrict public records. Deals with the General Assembly records themselves. Who writes the laws? The General Assembly. And they put in an exemption here in September of this year, basically exempting any documents prepared by one member and their staff communicating with another member and staff at the General Assembly. So if you get these, usually they do these Dear Colleagues letters, I want to propose this legislation. One of the members writes back to the other member, I don't think you should, or maybe consider that. Those used to be public records. Now they said, nope, all those communications between members and staff and another member and staff are not public records, at least for the current General Assembly. Once that current General Assembly is over with, that is after 2 years, then they do become public records. But if you think about it, we're looking at a budgetary process, multi-millions up to billions of dollars of the state operating budget. And next year we're going to have the capital budget where the legislators are spending our money. And if we want to see that whole debate going on between members, you cannot see it while that debate is going on. You got to wait till the end of the year. General Assembly is done for the whole session. A new General Assembly is coming in. Then we can give you the records after the bell's been rung. One of the good quotes from the Ohio Supreme Court on public records is, sometimes it's not important in terms of public records of what the record is, but when you get it. And again, through this enactment, General Assembly undermined that principle completely. Another exemption, which I'm disappointed in, is they have exempted, one of these 52 exemptions, exempted the work schedules of what they call designated public service workers. And the key, though, is what is the definition of a public service worker? It includes, and there's a big laundry list, but it includes law enforcement officers, prosecuting attorneys, fire, EMT. If an incident happens and something happened down the road, I want to find out what cops responded. I'd like to see the work schedule of who was on duty that day. That's no longer a public record. Again, who works for who? And another hurdle they put, not an insurmountable hurdle. If a government violates the Public Records Act, and they don't produce the records, they produce incomplete records, they redact records, you have the right then, as the person seeking the records, to file a lawsuit to get those records. You can file it. There's a short form and a kind of efficient that individuals can do at the Court of Claims. There's a one-page form you can fill out and file with them. I think it's a $25 filing fee. Or like the type of cases I take, we file them at the Ohio Supreme Court. The General Assembly said, well, before you file them, you have to complete this form, the one-page form, and send it to the government. After you've already made the request, you might have already engaged in dialogue with them, but before you sue, you've got to send them this form, and it should be sent either by hand delivery or certified mail. Additional expense, right? And they get, once the government gets that form saying, hey, I'm going to be suing you, et cetera, you didn't respond to my request, they got 3 days to respond. Now, it makes kind of sense. Hey, you kind of shoot the final shot across the bow to the government. Hey, you either comply or you don't. So it's not insurmountable, but again, it's just another hurdle that they are putting in to keep the people from their own records. And so what it's kind of prompted me to do when I'm doing these cases for clients is I'll send that form much earlier in the process. Hey, you're being difficult. Fine. Here's your 3-day form. We can still talk, but I've already taken care of that form. And hey, I'm going to drop the hammer anytime soon now. But so that's kind of what's going on there. There are some other changes, other exemptions out there. Another one that real quick, and I know I'll wrap up here, but public officials' calendars, and this kind of makes sense. A calendars of what the mayor is doing, where he's going, is a public record. They have, I think, from more security and safety perspective, says you do not have a right to their future calendar. You can see their past calendar, where they've been, where they were on this day, but to know what they're going to be doing next week is not a public record until they've already done it. That's pretty much it right now. But like I said, we each year it just seems we get greater and greater restrictions. I will say one other case was a case I had recently out of Montgomery County from the Ohio Supreme Court. Like I said, it's not just the General Assembly undermining that people's access to records. It's the courts too. And in that case, the court somewhat suggested and held that because a government official was doing something on his or her private email account, conducting government business, because those emails are not quote unquote kept by the government itself, it doesn't fall within the definition of being a public record. And I just think, the newspapers came out and supported me, filed stuff with the Supreme Court saying, you've got to revisit this issue. And unfortunately, only 2 of them said yes. The other 5 said no. We're fine with that decision. But if you think about, something like that, they're going to be conducting government business on private emails. I mean, you go back to the Gang of 5 case here in Cincinnati, when 5 out of the 9 city council members were discussing literally government business, talking about firing the city manager. All that was done on private text messages. At that time, it was understood that those text messages were public records. Those were released, and thus this, secretive operations by the Gang of 5 came to light. Today, city of Cincinnati is much more resistance. Hey, private emails, private text messages aren't public records. You don't get them. They don't even try to get them. So that's just kind of a warning, to keep an eye out. I'd love to come back to a full session on public records and open meetings for everyone. But, when you see your state legislators or that, talk to them about, hey, we need to get back to this openness and transparency of government. It's good for all. Be a Republican or a Democrat in office, what local government, county government, state government. It's good because, again, this goes to our government and our ability to hold them accountable. So with that, Dan?
Quick question or two for Curt. Anybody have a question that they would like to? There's a question online in the back. Let's go there first.
Someone asks, who makes the exemptions? Are they ruled on by another government agency?
No, the exemptions are put into the law itself. So it's section 149.43 of the revised code. They give this statutory definition of what is a public record. And then the next sentence says, the following are not, notwithstanding that definition, the following are not public records. And it's just a bullet list up to 50 plus or minus exemptions now as to what, even though they fall within that definition, the General Assembly, the state legislature, pulls them back out of that deal. So,
Got a question right here.
Hi. One of the reasons I've heard that they are starting to resist some of this is just the huge influx of public record requests that government is getting versus, call it 20, 30 years ago. And I don't know if you've tracked any of that or have seen any of that, but it's, a lot of them are saying it's just bogging them down. They can't even keep up with all the requests that come in.
I'm not going to dispute that. I would tend to agree. I think public offices, people are becoming more aware of their right to oversight of their government through public records. And I think a lot of the video issue, the $750 to get a video of a police stop or that kind of falls in that category. Oh, we're being overwhelmed. Oh, we're diverting. But it's interesting that the Supreme Court years ago basically said, the governments have the responsibility to timely prepare public records for inspection or copying, and they cannot decry too much of a burden or that. They've got to staff themselves in order to do it. I would not be surprised if that, the Ohio Township Association, the Ohio Municipal League, who basically represents between the two of them 99% of the local governments, or have a powerful lobbying influence in Columbus. And so they're coming there, they're harping in the ears of the state legislatures. Nobody's harping back on the other side saying, hey, what about the people? Unfortunately. So I would agree with you.
Would everybody give our guest a big thank you? Thank you, Curt.
Thank you. Glad to be here. Thank you.
Thank you.